Testing 1, 2, 3. Everybody good?
Still red. What does that mean?
That's good, Your Honor.
Yeah? Okay.
Well, welcome to Baltimore, Justice Elena Kagan.
Thank you, Dean Ron Weish.
Thank you. People who knew me then just like to say that. Justice Kagan needs no introduction in an audience of very attentive law students and law professors, but I'll provide a brief one. She's from New York City. She went to Princeton University, Oxford University, Harvard Law School, clerked for on the D.C. Circuit for Judge Mikva and on the Supreme Court for Justice Thurgood Marshall. She was a law firm lawyer, associate counsel to President Clinton, began teaching at the University of Chicago and then Harvard Law School. And after 2 years of teaching at Harvard Law School, you became the dean. That's pretty good. What took you 2 years? And then appointed by President Obama to be Solicitor General, the first woman to hold that title. Did that for about 1.5 years, and then President Obama nominated you to the Supreme Court to fill the vacancy created by Justice Stevens' retirement. And you've been on the court for about 3 years.
3 years coming up.
How's it going?
It's a good gig. No complaints. You know, I'm trying to learn the job. So there's a lot to learn, but it's really fun.
Good. Well, before we get too deep into this, I want to sort of say what we're doing here and what some of the ground rules are. Justice Kagan, as all of you know, has very graciously agreed to help us open our new building. And this evening there will be a ceremony. She and Chief Judge Bell will be featured speakers. That event, while it's invitation only, is going to be live streamed. So all of you are very much encouraged to watch it on our website. But since you can't be there in person, I asked the Justice if she would be willing to come up a little bit early and be with students. And I appreciate all of you being here. I appreciate our President, President Baltimore, being here as well. This is just a conversation, an informal conversation. I'll begin the conversation. And then you see there are microphones. Students and others are very much encouraged to ask questions. The one important ground rule, and this will surprise no one, is that the Justice cannot speak and therefore should not be asked about pending matters. And I'll police that, she'll police it, she knows how to stay out of trouble. Let me begin the questioning by saying that when we spoke recently in preparation for this, I said to Justice Kagan, Baltimore, you come into Baltimore, what's the connection to Baltimore? And she said, nothing. Have you been to an Orioles game?
Once or twice.
All right, well, so a little something. But thinking about it after...
But now we have our own stadium down in D.C., you know?
You've got, the Nationals, they're okay. As everyone here knows, I'm in both camps.
Is that possible?
But until the World Series it is. I found a Baltimore connection, and the Baltimore connection is Thurgood Marshall. Justice Kagan clerked for Justice Marshall in his last years on the court, towards the end of his career. But as many of you know, Justice Marshall is of Baltimore. He was born here. He went to high school here. He might have gone to law school here, except that the University of Maryland was segregated at the time. I don't know whether he considered the University of Baltimore, which was not quite, we were sort of a different institution at the time. But he ended up going to Howard, and then practiced law here until he moved to New York to do his pioneering work with the NAACP. So he is of Baltimore, and I thought that was an important subject to explore. Tell us about Justice Marshall in his later years. What was it like to clerk for him?
Well, the first thing is that he was a great storyteller. And the reason I mention that first is because he told stories about his entire life, and he told stories about Baltimore. So when you were clerking with him, you know, some days you learned all about what it was like to grow up in Baltimore at the time he grew up there. But he really, he was, as you said, I clerked for him when he was at the tail end of his career, and I think he was a little bit taking stock of his life. And that was sort of an amazing position for a clerk to be in, was to have the opportunity for a year to listen to this absolutely iconic American figure, I think the greatest lawyer of the 20th century, look back on his life and talk about the lessons he had learned and the experiences that he had had. And as much as clerking for a Supreme Court justice is always a great job. It's a very heady job. You know, there are these like 28-year-olds, and they come and they think they're kind of like making the law of the land, and it's very invigorating and exciting. But clerking for Justice Marshall was something on top of that you really did feel as though here you were day in, day out, talking with, listening to, learning from this this person who will go down in the history books, not only for his judging, in fact, not primarily for his judging, but for all the work he did before that, and listening to those stories and listening to sort of what he had learned and gathered from all his years of doing what it was an amazing experience.
I can imagine. I mean, was the experience of clerking itself formative for you? Obviously for Justice Marshall made it especially educational, but how much did you learn as a lawyer from clerking? And I ask that because many of our students, as I mentioned to you, clerk, especially in the Maryland state courts. We have a very high percentage of students. So some of the students here will be doing that next year or in the future. What was the experience like?
It's a great job. I mean, the two clerkships I had, the clerkships at a trial court level are very, very different from clerkships at an appellate level. And you have to sort of, if you have the option to clerk, or if that's a possibility, you sort of have to ask yourself which you're more interested in, which you want. Clerking at an appellate level is a little bit like being a student, honestly. It's a lot of researching and a lot of writing. Clerking at a trial court level gives you the opportunities to see things that at least I hadn't seen when I was a student, because law school was a lot less experiential there, a lot less practice-oriented, a lot more just like school. And clerking at a trial court level gives you the opportunity to watch lawyers in action and to see trials. And I had never had that. And I think I would have enjoyed that too. It's two very different experiences. But the clerkships that I did, I mean, they really did help me learn to write better, how to think better as a lawyer. And then I was lucky enough to clerk for these really two quite, Judge Mikva and Justice Marshall, two quite extraordinary men, both of whom had led these sort of amazing lives. And not just to watch their lawyering skills, which were very great, but just to learn from them as people. You know, they were both both really decent people, and people with the right values. And having them as models was an important thing for me as a young person.
And as you look for clerks now, are you looking for someone who is more mature? Are you looking for a writer? What are the qualities that you're looking for?
You know, I look for a lot of things, and if you could put everything together in one person, that person would be God, right? But I also look for a mix of people who I'll get different things from. I look for a mix of, I don't want like people who all think the same way or all think the same thing. That one of the things that I use clerks for is to get a range of different views, and I try to pick people who I think, it's hard to tell, you don't want to give, I don't like ask them really about, but I look at their resumes and I see what kinds of things they're interested in and what kinds of perspectives they have, and I try to get people who I think will give me, who will approach cases in somewhat different ways and have different views about some of the hard questions we deal with, so that I can hear a whole range of opinions.
Do you have your clerks write the first draft of opinions?
I do, but then I don't really much use them, kind of.
That's your story.
So it's a little bit of a depressing job in that way. But I tell them that they're really fun and good things I think about working for me. But I tell them that one of the things that is not so fun and not so good about working for me is you're not going to see your words in the U.S. reports. Right. But it's like the worst of both worlds, because I do tell them to write drafts, because the drafts actually help me to think about the case. Honestly, they often tell me like, oh, what not to do when I start writing myself. But sometimes they tell me, I look at them, I see what works, I see what doesn't work. I sort of use them as leaping off points in terms of my own thoughts about a case, and they're very helpful to me in that way. But the words end up being mine, and that's because I would like.
you got confirmed.
I got confirmed, exactly right.
You get to do it.
And, different people think in different ways. The way I think is I sit down at a computer and I start writing, and then I learn what I think. And I don't really know what the problems are in a case. I don't know what the hard spots are of the analysis until I really start writing.
So let's talk about your career a little bit, because I think it's interesting for students to see how did you get here from there. So you graduated from law school, 2 clerkships, and then to a law firm, right? Williams and Connolly at the outset?
The first thing I did was I went and worked on a presidential campaign. So I worked for Michael Dukakis.
How'd that work out?
Yeah, that was good. So here's, I started with Michael Dukakis the day after he got back from the Democratic convention. He was 17 points up in the polls. Do you remember that Michael Dukakis was once 17 points up?
Right, that was his slogan, like, this time confidence.
Yeah, well, 17 points up didn't last long. It was just a slow dive, or not so slow. But yes, but I had fun. I met a lot of people. I was very glad I did it.
I worked on the Howard Dean campaign. I don't know if I ever told you.
Wow, I really didn't have you down as that type.
It's a longer conversation. So, but eventually, Williams and Connolly, a law firm, and then soon enough to teaching. I mean,
Yeah.
Was that always a calling for you to be a law professor?
I didn't know. I thought possibly, but I thought I'd give the real world a try, because sometimes people, they're in school all their lives, and so they think they should just continue to be in school because they haven't really seen anything else. I did, try to see some other things, but in the end, I loved practice. I thought it was great. Williams and Connolly was a terrific firm, but I missed the opportunity to think more deeply about issues, and teaching is kind of a great job. I mean, somebody pays you to read and write for a living, and read what you want to read, think about what you want to think about. That's kind of a good job, and so I did about 2.5 years in, switch over to teaching.
And your first job as a teacher was at the University of Chicago.
Right.
And who should be on that faculty but Barack Obama?
Yeah, he was not then when I started, and I didn't really know him very well. He came out to Chicago during the time that I was a professor at Chicago. He came out to the city, and the law school desperately wanted to hire him. And in the end, we got him to sort of teach on a part-time basis. We never hired him as a professor.
He was in the state legislature at the time.
Was he? I'm not sure. I think he might have been actually at a law firm at the time. But the way I remember President Obama from that point was not actually as colleagues, but as I remember a number of recruiting dinners with him, where we were all trying to tell him how great the University of Chicago was and he should come join us. So I got to know him a little bit, not very well. I think by the time he started teaching at Chicago in earnest, I had already left and gone to D.C. again. But we became sort of friendly acquaintances, which, was a nice thing later on.
Right. I was thinking about, I had more of an impression that you were colleagues, and I was thinking, pretty nice of a colleague goes on. I mean, it would be, sort of, to translate for this audience, it would be like, if Dave Jaros got himself elected president, he could appoint Will Hubbard to the Supreme Court. That's an insight.
Okay.
So, but you found yourself back in Washington, White House counsel's office, nominated for a judgeship. You were not confirmed, and we could talk about the crazy confirmation process, but then to Harvard. And you had a very successful career there as first a teacher and then a dean. I'm sort of fishing here, but what's it like to be a dean?
You don't know yet?
I'm still learning.
Well, one of the great things about the job is that you learn every day. And I loved being a dean, and one of the things I loved about it was that I used more muscles than I had in any other job I've ever had. In other words, that there were more different skills, and one day you were doing one thing, and the next day you were doing another thing, and they were the kinds of things that the same person does not do all of those things well, or at least does not do all of those things naturally well. And so anybody who has the job, I think, has to learn some set of things that they have never tried before, have never done before, maybe aren't naturally good at, but sort of have to push through whatever natural incapacities one has but it was so much fun because of that. I mean, I think the most fun jobs are the ones that you're learning every day, and I really did feel as though I was learning every day and developing new skills every day. And I loved the community that I was dean of, and that's a really important thing. And if you have that in your community, and I know you do, because I've heard you talk about this place, and they're lucky to have you, but you feel as though you're lucky to have them, and that's a tremendous way to have a deanship.
I mean, it seems to me that being a dean is, in many ways, the most social job in the world. You're sort of out there talking to professors, to students, to alums, to community leaders. And now you find yourself in what might be the least social job as an appellate judge.
It's good that the work's interesting.
I feel sort of a good thing that I asked you to come out here. Right? I mean, to meet people. Right?
You start for company. Yeah. You know, it is. It's a quieter job than some of the jobs I've had. Not than all of the jobs I've had. I mean, I remember making the transition from, I spent 4 years in the White House, which you kind of skipped over, from 1995 to, that's all right, from 1995 to 1999. And you know, when you work in the White House, it's incredibly hectic and incredibly fast-paced and really nerve-wracking in lots of ways. But it's just a zillion miles an hour. And then I went back to teaching after that, and I got back to Harvard. It was actually in the summertime, so when a school is the deadest of any time. And I remember sitting at my desk thinking, surely the phone is broken, you know? Just like, and so I've had jobs which have been more or less social. So this one is, you know, there are the 9 of us, and I think we actually spend more time talking than most people think. And then there are my clerks, and then, you know, you go out, you do events like this, go out, talk to people, talk to groups. You know, there are enough people to.
The experience of having been a law professor and a dean, how does that influence your work as a justice? Do you pay more attention to the law review articles than the other justices, or less?
You know, I probably look at law review articles maybe a little bit more than the average justice. But I think that the way it affects my work is when I write opinions, I approach opinions. I became aware of this sort of. It sort of all of a sudden occurred to me that when I think about writing an opinion, I think about it in the same way as I used to think about preparing a class. That I used to think, well, here's this hard material, and people don't know about this stuff, and it may be very difficult concepts. And the question of how you explain something clearly, lucidly, but also persuasively and in a way that makes it stick with people so that people remember it is, I think, something that I thought long and hard about when I was teaching and made me, I think, a good teacher. And I think that's something that I've tried to bring with me to opinion writing. I use a lot of hypotheticals in the same way that I did in the classroom. Like the way to think about this is compare it to that, and you have a kind of visceral reaction to that, and I'm telling you it's really the same thing, that sort of thing. You know, sort of thinking through a problem, with an audience in mind, and trying to figure out how to convey to an audience the complexity of the question, but also, you know, why what you think about the question is the right thing to think about the question, is, I think, something that I learned to do as a teacher.
You've gotten good reviews for being a lucid writer, for someone who is explaining the issues at stake to a wider audience, and that's really a compliment.
Well, thank you.
I want to sort of get a little bit closer up to the present in your career and ask you about being Solicitor General. This is when you and I met. You're nominated by President Obama. You had, am I correct, you had never argued, not just in the Supreme Court, you had never argued a case in an appellate court.
That's right.
Before.
I had only done district court arguments.
So here you are, you're going to be the representative of the United States government in the Supreme Court, and your first case, not some, you know, bankruptcy or, they give you Citizens United.
Yeah.
That's going to be your maiden argument in the Supreme Court.
Right, the big campaign finance case.
Were you nervous?
Yeah. I was nervous. But here's the thing about Citizens United. You know, everybody thinks, oh, it's a really important case. And it was, and it is. The way I came into Citizens United was, you remember Citizens United was argued once in the spring, and then at the last day of that term, the court issued an order saying that it wanted to hear re-argument, and it specifically said it wanted to hear re-argument on the continuing viability of a couple of cases. And it was really clear, if you read that order, it was really clear, what the writing was on the wall. And so as much as I was nervous and as much as I thought this was a really important case, I also sort of had the view that they had decided this case already, and or close to it, and that nothing that I was going to say up there was going to make an enormous difference. And I don't know anything about the ins and outs and of the process. It was before I came, and I haven't tried to learn. But that's my suspicion: is that my argument, it could have been the best argument in the world, and they had, I think, already they had heard argument before. They had thought long and hard about the case. They thought it was important, the court did, to give the lawyers an opportunity to address some of the bigger questions that had not been briefed as thoroughly as they might. They gave people that opportunity, but I doubt it changed very many minds.
In general, have you seen oral argument change the result in a case? As a justice, have you had your mind changed by oral arguments?
Yeah, but often not in the big profile cases. A case like that, basically, it's likely, not inevitable, but it's likely that people will have views about the really big issues, that they'll have seen those cases before, they'll have thought about those cases before, and nothing you're going to say in oral argument is going to be so new or surprising to anybody. But there are lots of cases we do, that don't have that quality at all, where the question presented is new, you're coming to it for the first time. Even my colleagues who have been on the bench for 20 years, some of them or more, where they've never seen a case quite like this. They don't have priors on it, and in those kinds of cases, which is a substantial part of our workload, the briefing can make an enormous difference, and then the argument can make a real difference.
You talk about the less high-profile cases, and I'm always pained to see people, and I hope not students, think of the court as just these political blocks. You got the liberals and the conservatives, the Democratic-appointed judges, Republican-appointed judges, and in high-profile cases it sometimes splits like that. But am I correct that it's often other kinds of splits, and it's not like you don't have a secret lunch with Justices Breyer, Ginsburg, and Sotomayor separate from the others, right?
No, if there's a cabal, I haven't.
They haven't invited you.
That's right. No, that's exactly right. I mean, a lot of our cases, much more than people know, are unanimous, right? I think probably about 40% of our cases are unanimous. I think about maybe only about 15 of 80, so what does that equal, are the typical 5-4 splits. The 5-4 splits that everybody thinks of. Maybe 10 or 12 or 15 cases a year have that quality of there are 4 people over here, and then there are 4 people over here, and the question is, where is the the 9th person going to land? And you don't want to say that those cases don't exist. They obviously do, but it's one part of our workload, and then there's much on which people all the time look at cases, I think, and say, well, that's a crazy kind of, it might be 5-4, but 5-4 like Justice Scalia, Justice Thomas, Justice Ginsburg, Justice Sotomayor.
Criminal sentencing, for example, I know it's often Scalia on the more liberal side, if you will, the pro-defendant side, and Breyer often on the... Right.
There are often, in criminal cases, sort of splits that you don't expect that are not the stereotypical ones. So I think we're more unpredictable than people give us credit for.
Let me, I feel like I'm being selfish here. I'm enjoying asking questions, but I want to give everyone a chance. Why don't I ask people who are interested in asking questions to line up behind the microphones, and I'll sort of keep going for a little bit as people get lined up, but please feel free to ask the Justice. Some of the cases are a little bit esoteric. You get an antitrust or an intellectual property case. Isn't it weird to be writing an opinion in an area that you're not expert in, and you know that there's a community of scholars and practitioners out there who are going to dissect it?
Well, it keeps you on your game, you know?
Yeah.
I mean, if you sit there and you think, this is my first bankruptcy case, and there's a world of bankruptcy lawyers out there who know more than I do about bankruptcy, It makes you work really hard, and I spend as much time on the more arcane, complicated, statutory, the ones that are never going to make it into the newspapers. I spend as much time on those opinions as I do on some of the more high-profile cases, and partly it is this sort of sense that there's a specialized community of lawyers out there for whom this is very important, and who will, you should get it right.
That's right. All right, let's start on this side, and we'll go back and forth. Question for Justice Kagan. Please introduce yourself.
Justice Kagan, my name is DJ Carswell, and I'm a 1L here at University of Baltimore. And my main question is regarding the hiring of law clerks in the Supreme Court, because of the trend of having Ivy League students being hired as law clerks. Do you think that the Ivy League schools produce better students or better lawyers, or do you think that it is the networking and the other opportunities that are available at those schools that may increase or enhance the chances of being chosen as a law clerk for the Supreme Court?
Well, first I'll say guilty as charged. I've picked my clerks from a relatively small handful of schools, and I feel a little bit mixed about that. Like, on the one hand, I think, well, that's not very good, and the reason why it's happened for me, quite honestly, is that I know faculty. Well, honestly, I know faculty best at Harvard Law School. And I'm very, very confident that the people who, I call and I say, really, who have you got for me? And will give me really honest evaluations. And so I think for me, it's mostly that I rely a lot on professors' recommendations, people who know the students really well, but who also know me really well, and who know when there will be a good fit, and who I know will be honest with me. And because you don't know everybody at every school, but there are great students at every school, and there are students who could do this job, the job of a Supreme Court clerk at every school. And I think I have to do better at casting my net wider. The person who is...
We're going to send you our best.
The person who is best at this, because I think, quite a number of us could say guilty as charged. The person who is best at this is Justice Thomas, who I think very self-consciously reaches out to lots of different kind of schools, and especially he's the circuit justice, I think, for the 11th Circuit, and he picks a lot of people from different schools in that circuit, and I think it's a really good thing that he does.
Great.
Thank you.
Question over here.
Hello, Your Honor. Thank you for coming. My name is James Sensor. I'm a 2L. I was wondering, you had, over the course of your legal career, a lot of opportunities to read the opinions of many of the justices you're working with now. And I was wondering, based on reading those opinions, how are some of the justices maybe different personally than you would have thought over the course of reading their opinion?
Oh, what an interesting question. Well, I will say this. I'll be sort of a little bit general about this. I think often people read our opinions and they think we must not like each other very much. Because sometimes the opinions are you're sort of throwing brickbats at each other. And, I'm not pointing fingers because I've written some of those opinions myself. I've written some pretty harsh dissents. And maybe sometimes some dissents where, I go back to them a year later and I think, did I really have to use that line, But so, quite a number of us, can be harsh in print about the views of people who came out the other way. And I think what people don't realize, and it's sort of a remarkable thing, quite honestly, is that we like each other an enormous amount and respect each other an enormous amount. It's a very collegial court, a very warm court, and I think we just sort of understand that it's part of the job, that sometimes that you're going to have differing views and you're going to express those differing views, and sometimes even express them in a way that says that the people who hold the other position are really are really making a very fundamental mistake. But at the end of the day, I think what's great about this court is that we all think that everybody's operating in good faith. We have different views about how to read the Constitution. We have different views about how to read statutes. We have different views about the most fundamental commitments of the Constitution. But I have zero doubt that every single one of my colleagues is operating in good faith and is trying as hard as he or she can to get these cases right, and I have zero doubt that I can learn from all of them. So I think that when you see the opinions, sometimes you don't realize what a collegial and warm court it is, and how much we all think we can learn from each other.
That's great, thank you. Question over here.
Yes, Justice Kagan, thank you for coming. I'm Kate Rosenblatt, I'm a 2L, and it's a little derivative, but I'm curious about your motivations in writing dissents. I'm sort of wondering if it's to air your opinion and argue the other side, or perhaps to lay groundwork for a future challenge in front of the court.
It really depends on the kind of case. Writing dissents is fun, first off. You can be a little bit more yourself when you write dissents or when you write concurrences, when you're writing for yourself rather than for the court. So when you're writing for the court, you have to be a little bit buttoned up, But when you're writing for yourself, even if other people join you, if it's not the majority, if it's not writing for the institution, you can be a little bit looser in your style, and you can sort of let a little bit more of your own personality show through in your writing, and that's really fun. Although it's never fun to lose, so, like something that you really wish you had been. I mean, it's more fun, honestly. It's more fun to write dissents. It's more fun to be in the majority. But what my sort of the objectives of a dissent really vary. I mean, sometimes you're just writing a dissent because this is a hard question. There are two sides to this question. If the court were to come out 9-0 in this question, it would actually be not true to the difficulty of the question, and to the extent to which the lawyers on both sides made extremely good arguments, and there's nothing wrong with sort of saying, this is hard. Here's the opposite point of view, but then you have no expectation that somebody down the road the court is going to shift or your dissent is going to become a majority. I mean, it's just not that kind of case. We're going to decide it, and then it's going to be decided, and life is going to move on, and all the people on the dissent will understand that we've made a decision, and then they'll get on board, and you're just doing it in terms of almost treating the litigants fairly, treating the lawyers fairly, and treating the law fairly in terms of saying it's not so easy. But then there are some cases where I think you do have bigger goals in mind, where you do think, this is going to be a continuing battle over this issue, right? I wrote a dissent my first year in a campaign finance case, and you just understood when I was writing that dissent. I understood that there were going to be more cases like this. They weren't going to be the exact same case, but there were going to be more cases like this, where the arguments on both sides were going to be roughly the same, and they were going to, and different people had really different views, and that this was a salvo in what was going to be a longer controversy, and that you tried to write a dissent that took account of that fact, that took account of how this controversy was going to develop over time, and laid down some markers, and laid down some, and maybe tried in the way you wrote the dissent, tried to change people's understanding of the majority a little bit, maybe even to change the majority before it went out the door. And also to lay down some strong opinions of really what the law in this area should look like, and hopefully will look like, however many years from now. And there are certainly opinions, certainly dissents that have been written over the whole history of the United States that have been important for changing people's view of the law and, over time, changing legal doctrine in an area. So sometimes you write a dissent like that. More often dissents are just, this is a question, it's obviously an important question, it got here, we disagree, here, we lay out the disagreement, then we move on.
Thank you.
Question over here from John, who's going to be working at the Justice Department this summer.
Sir, my name is John Baber, and I'm a 2L. Justice Kagan, I was wondering if you could tell me, among your colleagues on the court, who you find most entertaining and humorous. I mean, is Justice Alito like a practical joker? Or?
Well, I'm not. So, there's some outfit that counts the number of times we elicit laughs in the court. And there's actually, I forget where you go to see this, but I check every once in a while. And I would say that the view of the spectators in the Supreme Court is very clear on this question, that the funniest justice is Justice Scalia. I think Justice Scalia has elicited more laughs in the court than almost everybody else put together. The second funniest is Justice Breyer, and I'm very, very down the list. I'm not doing so well. And in fact, one of the people who counts this thing. I mean, can you imagine people sitting there with the transcripts going, it goes laugh, right? 1, 2, 3. So and there's a professor. I'm not going to. There's a professor who I think is in charge of putting all these things together. Anyway, he editorialized one day that I was underperforming. He was confident I was funnier than I was showing in court, and that I hope I'm funnier than what I'm showing in court, given the number of laughs I get. Not very many.
You're just getting started. I mean, you get a couple of years to kind of ramp up. We have a professor who is also a Supreme Court reporter, Garrett Epps, who's here. I don't know if Garrett wants to opine on whether Justice Kagan's humor is improving.
I know Professor Epps' son.
Oh, yeah?
Yeah.
Let's see. Thank you.
Professor Epps' son was a student of mine.
Yes.
Great guy.
Question here.
My name is Ben Beasley. I'm a 2L. I'm going to try not to violate the ground rule, but I'm going to back up in case I do. My question is a Second Amendment issue, and you've got several. There's a split among some of the circuits, and I know the court.
I'm not going to answer this question.
Well, my question just is is the court? Do you think the court's ever going to address the extent to which the Heller holding is? Because there's several different splits among the circuits, and if so, how long that might be?
Yeah, that really falls right in the heartland of the things I'm not going to answer. So sorry.
Well, my backup question is, what was the hardest thing? What was the hardest thing about the confirmation process?
I think the hardest thing about the confirmation process is listening to people talk about you for however long it lasts, a couple of months. So the hardest thing about the process is not the process, it's actually the press. It's just, you turn into a public figure so quickly, and then everybody starts talking about you. And both the people saying good things about you and people saying bad things about you, it doesn't actually seem like you. So you read all this stuff about you, and you think, who are they talking about? Now, of course, the people who are saying good things about you, it's like, okay, fine, I'm not really like that, but it sounds good, But I think about the hardest thing about the confirmation process is just sort of listening to the stuff that people say about you that honestly bears no resemblance to your own view of who you are. I had a good time in lots of parts of the confirmation process. I'll tell you what was good about the confirmation process was. Everybody sees the hearings, but before the hearings, there are all these courtesy visits. Ron has probably sat in at about 90,000 of them. I did 82 of them, I think. So 82 sit-downs with individual senators, and some of them were 10 minutes long, but some of them were an hour long. And actually, I thought that process was really a lot of fun. I could count on 2 or 3 fingers the number of times where I felt anybody was discourteous to me. For the most part, people were extraordinarily courteous and often really engaged, really interested in learning about me. And often some unexpected people I found that way. And I liked putting faces to names, and I liked getting to know these people who were really impressive people for the most part. And so I enjoyed that. And then I really enjoyed, quite honestly, the hearing itself. So I'm a little bit of a ham, and I like an audience. And that was kind of a great audience. You go in there, and the lights are right on you, and you think everybody's watching, and it brings out a little bit of the exhibitionist in me, and the performer part of me, and I like talking about law, and I think I'm often pretty cogent when I talk about law, not always, and so I enjoyed that.
I regard myself as a connoisseur of the confirmation hearing. As you say, I've sat through many of these, and you were great. I mean, because the trick is you have to give enough to make them feel that they're having a real dialogue with you, but you can't cross the line of making a pledge about how you're going to rule in the case.
Right.
And you found just the sweet spot. So
yeah, I think it's a frustrating process for a senator, and I completely understand why. Is because in the end, they want to have answers to the kind of thing that you wanted an answer for, and in the end, a nominee's not going to give them that, and so there is this sort of gap between what a nominee is likely to give, even a nominee who I think I really tried to talk very forthrightly about my views about judging, about my views about how to do constitutional interpretation, things like that. But in the end, they want to know, well, what do you think about the Second Amendment? And it's just a hard situation.
The depressing thing about the confirmation process, you were, as I say, really good at being forthcoming as much as you could be, and I'm sure you were very charming in the courtesy meetings. And at the end of the day, only 5 Republican senators voted for you, and 3 of them are no longer in the Senate, so we're down to very few. And you just wonder if we're coming to a point, and I hasten to say that Democrats treated Republican nominees with that kind of approach. We're coming to the day where our members of the party, it's not the president's party, never going to vote for a nominee.
Yeah, I think it's really quite sad, and it keeps on getting worse and worse. And part of the reason it gets worse and worse is because it's really tit for tat. Everybody has memories of what the other side did to their people. You see this not only at the Supreme Court. You see it. You mentioned that I had been nominated for a judgeship earlier, the D.C. Circuit, and that's one where they go, well, there was Elena Kagan, and why didn't she get a hearing? And then they'll say, well, there was Miguel Estrada, and he was unbelievably qualified, and why didn't they vote him out? And it goes, exactly. Just and it keeps on getting just ramped up, right? Because each time the bitterness gets worse.
Yeah, it's sad. Question over here.
Thank you for coming to visit us, Justice Kagan. My name is Dean Chrisman. I know Dean Wire said we couldn't ask about pending matters, but I just wanted to know if there's an issue since you've been on the court where you wrote the dissent that you still feel very strongly was decided incorrectly, and why.
Yeah, the dissent that I mentioned earlier, in the dissent I wrote my first year, which was about a campaign finance case. It was about a public financing scheme in Arizona and whether that public financing scheme was constitutional, and I said it was, and 5 people said it wasn't. And in campaign finance cases, we often do split along what we were talking about as this sort of stereotypical way, and I think that these cases are hard. I'm not saying there are really important values on both sides, and so I understand why it is that the court is so closely divided. But I also think that the court in that case did reach the wrong result. That the campaign financing law in question really was trying to improve the quality and the honesty of government without any appreciable limitations on speech. It was a public financing scheme. It was actually a scheme that was devoted to paying people to speak, not actually to imposing restrictions on anybody's speech. So I thought that the court got it wrong, and I hope one day maybe the court will get it right.
Hi, Justice. My name's Annie Vanslow, and today's actually my very last day of class.
Congratulations.
Thank you. My question for you is
Of course, the last day of class means it's pretty soon to the first day of exams, right?
That is true.
I don't want to...
It's the last exam forever. My question for you is just based on your experience and your wealth of knowledge, as a new attorney, what advice do you have for us?
Work hard, learn a lot. I think that sometimes lawyers, they sort of focus on one thing, and they miss a lot of what's going on outside in terms of career paths. You sort of say, okay, I'm doing this, and then and a lot of life is serendipity, and being open to the weird paths, the weird things that might fall in your lap. Even and you say, well, it'd be risky to do that. It would, it's not what I expected to do. But there it is, and it seems kind of interesting, and it seems kind of exciting. I think in those kinds of things, you should grab it. I think, like a lot of law students, they sort of have plans, and they have, one thing that there's, and the great thing about law is that there is so many different kinds of opportunities, and just keeping your eyes open for all of it, and trying to figure out what makes you passionate and what just gives you the desire to come into work every day, and is something that's not going to be just your first few years. It's hope that sort of quest for challenge and excitement and the things that give value and meaning to your life, last all your life, and to keep your eyes open for it.
Can I put a fine point on that? You've had a couple of professional disappointments, right? So we talked about the fact that you were not confirmed when you were nominated for the DC Circuit, and then it's a public fact that you were a finalist for the Harvard presidency. You didn't get it. That was probably disappointing. But
there are a lot more jobs that I didn't get than that I did.
Yeah.
That's
good for people to know.
Yeah.
And I mean, a lesson there is sometimes something that doesn't happen can lead you on a path that leads to something even better, or in any event, something that was meant.
Yeah, I am such a big believer in that when one door slams shut, someplace a window is opening, and that sometimes the opening that's created is a lot better than the door that's been shut. And it was. I was a finalist for the Harvard presidency. I didn't get it. I was very disappointed at the time. If I had become president of Harvard, there is no way in the world I would be sitting where I am now, So,
life is fun.
Yeah, exactly.
Question over here.
Hello, Your Honor. I'm Sarah Moses. I'm a 2L. I just had a question regarding your thoughts on the current public accessibility to oral arguments in the Supreme Court, whether it should be increased, decreased, or you like the status quo at the moment.
Yeah, I think it's a really tough question. When I was actually asked about this at my confirmation hearings, and I was, pretty strongly in favor of. I think that there should be cameras in the courtroom, and what I said was, I think we do pretty well for ourselves as an institution. I think we look pretty serious, and we look as though we're trying to get to the right answers. We all come in prepared. We're all I think, devoted to getting the answers right, and I think we look that way. And I always used to think when I was Solicitor General that one of the most fun things about the job was actually just sitting there and watching the Supreme Court work. And you do that, and you think it's such a shame that not everybody gets an opportunity to see this, gets an opportunity to see some of the important decisions being made, but also to see an institution of government really work and work, I think, pretty well. So there are obvious reasons why people should have more accessibility to what we do and have more of a chance to watch us. But there are also downsides, and I think maybe I've thought more about those downsides since I came to the court. But there are downsides. A worry that once you put the cameras in and once everybody starts focusing on how the sound bites and that it changes the thing itself. And if you thought that the cameras would decrease the quality of the judicial process, that seems to me as though it wouldn't be a good trade-off. And what's so hard about this decision is you don't really know, do you? I mean, until you try, and you have worries, and the question is how risk-averse you want to be, I think. And I think it's a really hard call for that reason. I think you understand why people want more transparency, and I think it would be a good thing for people to know more about us and how we do our job. And I think that if they saw us, they would respect what we're trying to do. But at the same time, you don't want that very transparency actually to change the institution in ways that I think it's possible that it could. I don't think it's like crying wolf or just sort of crazy paranoia. Is that once you introduce the ability to film us, to take things out of context, that it might really change the way we do our jobs. So I think it's really hard.
So one last question, Zarina Sita.
Hi, Justice Kagan. Thank you for coming. My name is Zarina Sita, and I am a 2L. My question is, a lot of times terms and phrases that are in opinions become legal terms of art that law students end up using as buzzwords on exams. And I was wondering if, in writing those opinions, the justices take that into account and specifically phrase things certain ways for them to become legal terms of art.
Are you thinking of something in particular? Do I get an example?
Oh, well. I have an image of Professor Meyerson, hope you're not here. If you are, I'm sorry, of Professor Meyerson running back and forth in our con law class talking about strict scrutiny, and just, screaming it out at us from different sides of the room.
Well, I mean, some of those phrases, you just, they come to you, right? I mean, they're just so much a part of the legal doctrine. I mean, you almost can't write some kinds of opinions without using the phrase strict scrutiny, and whatever you might have thought about that phrase in the first, instance, that ship has sailed, right? And it's just a part of the doctrine now. So now, the question of do we all sit there and try to think up phrases that will become like that, right? That will become the phrase that everybody uses for 50 years. I doubt we're quite that self-conscious about things, I think probably law doesn't really develop that way with, people just sort of sitting down thinking, I'm going to develop, the great 3-word phrase that will be the buzzword for the next 50 years. I think often, it happens accidentally. My scholarly focus was I did administrative law, and the case that everybody talks about, thinks about, the test that everybody uses in administrative law comes from this case called Chevron, which is a test about when you defer to administrative agencies. And you cannot write an administrative law decision without starting with the 2-part Chevron test, right? And if you ask Justice Stevens, who was the author of that test, did you really think, that this was going to be the way that people considered administrative law issues for the next 50 years? I'm quite sure he would tell you no, that it was kind of an accident. He happened to write an opinion that was very clear and straightforward, and that had a certain kind of made sense in certain kinds of ways, and was also just very okay, well, that's a good way of looking at it. First we ask this, and then we ask that, and all of a sudden that was the way you did administrative law issues. And so I think a lot of these things are accidental.
Thank you.
Well, thank you, Justice Kagan. Our time is up. I want to
Thank you.
I neglected to thank Justice Kagan for wearing Ravens purple. Thank you all very much.
Thanks a lot.